Good morning, everyone. Let's begin. AS10. So we will be covering today Article 21 and procedure established by law, due process of law, natural justice, principles of natural justice, Article 24, Article 25. Okay. So protection of life and personal liberty, Article 21. No person shall be deprived of his life or personal liberty except according to procedure established by law. So this article is the spine of part 3 and part 4 of our constitution. It's the fundamental of our fundamental rights. It is the article that empowers our other articles. For example, in our article 15.2, we say there will not be any discrimination on the basis of age and sex. Similar for 16.2. Similarly, on 17, we abolish untouchability. On 18.1, see, just we abolish titles. Basically, providing everyone equality. So this article is not just what's written over here. Supreme Court has observed that it's not just life, it's dignified life. And it's not a single right, it's a composite right. And a large number of derived rights have been driven out of it by High Court and Supreme Court. For example, right to marry. The case in point will be the Hadia case in 2018, where Kerala High Court issued a habeas corpus writ uh, when her father approached the court that her daughter is missing. The daughter appeared, and what happened was like the court nullified her marriage because it also involved a conversion to Islam and then marriage, and handed over her custody to the parents. Now the husband of Adia went to Supreme Court and filed a special leave petition, and there the Supreme Court said that she is an adult and of sound mind, and she have autonomy over her personal choices, and so the marriage is valid. The Kerala High Court has earlier avoided her marriage. Similarly, the other one, like the right to love or right to privacy, right to sleep, right to shelter, right to change name or surname, go abroad, internet, speedy and fair trial, reputation. For reputation, we can see the current uh, scenario where Rahul Gandhi got dismissed because he said Modi word, and it was against the reputation of the people who have surname as Modi, and there was a defamation case against them later on. So right to reputation, shelter. You can see a number of rain baseras now in Delhi because of this right to shelter. Right to die with dignity. So there was a case where a nurse was ill, and so Supreme Court in 2018 finally gave the verdict for a terminally ill person. Passive euthanasia can be done. Living will can also be done. So the right to die with dignity is also there. Keep in mind that suicide is not a right. Suicide was in fact a crime. It has been decriminalized under the Mental Health Act 2017, and but it is still punishable if it's for against public order. For example, if to incite some offense or something like that. Similarly, right to choose sexual partner. Case in point would be the Navtej Singh Johar case in 2018, where the Supreme Court finally decriminalized all consensual and in adults sex. So, including the homosexual sex. So that was the Navtej Singh Johar. You can choose your sexual partner irrespective of their sexual orientation. Another thing was the recent one in 2023, Sadanand versus CBSE. So Sadanand was the older brother of the two brothers whose father name was Lakshman Mochi. The father has changed his name from Mochi to Lakshman Narayan. But, sorry, Lakshman Nayak, not Narayan. Lakshman Nayak. Because he was facing discrimination on the basis of the keyword mochi. People don't used to call him by his first name. People used to call him by uh, his second name, the surname, the mochi, and it was discriminating for him, and he was facing disability for it. So that was allowed. He failed. He followed the process, published his name in caveat, and everything for him was done. But when it came to his sons, the two brothers, Sarand and his younger brother, the CBSE declined to change their father's name from Mochi to Nayak. So that was the case, and Delhi High Court has directed CBSE to do it because it's under right of life, a dignified life, so that you can change your name. Going on. So the two keywords that came here, no person can be deprived of life and liberty except according to process established by law. Now, this word process established by law has its roots in England, where the legislature is supreme, kind of sovereign supreme. So it causes some issue. So we will be discussing that and what's the difference between process established by law, which we have in written in Constitution, versus due process of law. So both of these are for judicial review. And what happens is, like, there are 4 points. 3 are common between both of them. Fourth one is different. What's common? First one is like, so the idea is like both are to check the arbitrary powers. Due procedure established by law curtails the arbitrary powers of the executive. And the other one, due process of law, will curtail the arbitrary powers of both executive and legislature. So coming on, the judicial review for due process by law, we will be checking if there was a, when the executive had done something, was there any law under which the executive has done his work? Second, was the law passed by a competent authority? Like, was it under their list? Were competent to do that? That's all it's done. Then, was the procedure followed? All the correct procedure correctly followed by passing that particular law. So the procedure established by law, only these 3 things are checked. Nothing regarding if the law is itself fair or not. That's the point which is covered under the due process by law. And if the law is fair or not, that is determined on the basis of principle of natural justice. And procedure established by law is a bit of restrictive one than the due process of law. Due process of law, where we can see that judiciary is more powerful, has its origin in USA. And the procedure established by law has its origin in UK, England, sorry. And basically it depends on the good sense of legislature and the strength of public opinion. So our constitution provided Article 21 with procedure established by law. But in Menka Gandhi case in 1978, Supreme Court establishes that the interpretation of Article 21 will be including the doctrine of due process by law. Also, if you think of it, like, due process by law is not a violation of procedure established by law. It's an extension of it, because other than the 3 points, was a law which the executive used, was a law was passed by competent, and was all procedure followed during passing of law, are included in due process by law. It's just one more point, the fairness of law is also checked now. For example, the case in point can be the Shreya Singhal case in 2015, when Supreme Court struck down the Section 66A of IT Act 2000, as it violated Article 19(1)(a) and was not fair, because it was curtailing online speech. The law was something on the lines like, if someone feels offensed by your speech, authorities can put you in jail. So that law was struck down by the Supreme Court. Shreya Singhal was arrested because there was a Mumbai Bandh called by Shiv Sena, and after the death of their Supremo, and she called it out like it should not happen. And a case was filed against her. She was arrested. Parents reached out to Supreme Court, and all these things happened. Now, the principle of natural justice, which is being used here, is it consists of three major points. Like no person should be punished unheard of. He should be given a hearing. Second point, a person cannot be judged in his own case. Though, if you remember, there was a scenario where Justice Gagoi was the judge is in case of sexual misconduct in court that was on him. So that was there, but it's a counter example, you can say. And the third one is authorities should act bona fide, that is in good faith. Example being like there are, let's say, a colony where there is unregularized construction, but only two buildings are being demolished because the owners there have not given money to the police. So that's a non-bona fide action. Principles of natural justice are universal. They apply to all: judiciary, president, private individuals, everyone. And as we know that they are not explicitly mentioned in constitution, but they are the inherent principle of our articles. For example, Supreme Court has said for Article 14 and Article 21 that they are inspired by natural justice, principle of natural justice. Moving on to Article 24. This article prohibits child under 14 years for employment in any hazardous place, prohibits hazardous employment or factory or in mine. Yeah. But our parliament brought a law, Child Labor Protection Regulation Act 2016, which states like person less than 14 years cannot work except in family enterprise or entertainment industry and after school hours. So you can work there after school hours. So what Article 24 was missing was like it only was prohibiting to work in for children under 14 in hazardous places. Now Article, it didn't say anything about non-hazardous employments. So there came our parliament and established the law, the Child Labor Prohibition and Regulation Act 2016. And it clearly says that for less than 16 years, only after school hours you can work, and that too in family enterprise or in entertainment industry. Entertainment means movies, commercials, something like that. Between 14 to 18, you can work, but in non-hazardous. So if you think actually you cannot work less than 18 in any hazardous place, because though our constitution allows it after 14, but our laws stops it. And then after 18, the law says that there's no limit, you can do what you want. Now, Article 25, here we start on the religion basis, the religion articles. It 25.1 provides people the freedom, a twofold freedom basically. One is of conscience. It's an absolute right, the conscious one only part. It's the faith and belief, and state do not interfere here, right? The second part is to profess, practice, and propagate your religion. Now, that's not your inner thing. That's a, you can say, outward expression of your inner belief and faith, right? So here, state can put restrictions on you. Any conduct, because any conduct and practice can be regulated. Your inner faith is not subject to state, but your conducts are. So yeah, people have these freedoms subject to public order, morality, and health. Now there's 25A, 25(2)(a), which say that state can regulate or restrict any economical, financial, political, or other secular activity associated with religion. And 25(2)(b), specifically for Hindus, Hindus include Jains, Buddhists, that social welfare and reforms, and open religious institutes of public character to all classes and sections of Hindus. Right? Coming back again to the right to profess, that will be like telling your content, spelling it out freely, openly. To propagate, again, how will you propagate? By telling your content, by books, by seminar, culture programs, by conversions also. Now, for conversions, threat, temptation, these are illegal. You cannot do that. And there has been for example, temptation means for marriage also. Then both marriage and conversion will be termed void. If you remember, Dharmendra converted and Hema Malini converted to Islam to get married. I don't know what happened over there, was it valid or not, but as per law, it should not be. There was a famous case of father's tennis laws versus Madhya Pradesh government in 1977, where Supreme Court simply said that right to propagate don't include right to convert. That is, you have the fundamental right to spread your religion by explaining the content, but no fundamental right to convert others to your own religion. Right? Right to practice. Now, right to practice basically means to follow rituals and practices. These can be termed as something as essential and something as non-essential. For essential, generally the code do not, it's not banned, but it can be regulated. For example, namaz during flight is not allowed. It's being a regulation, and something can be banned. Like Supreme Court has told of no tandem in public to Anand Marks Act in 2004. So it was not an essential practice. The sect was established long before this standard practice came later. So Supreme Court simply said that it can be banned. Another could be FGM, female genital mutilation in Dawoodi Bohra community. That's still judgment has not been passed on it, but that too will qualify for non-essential. Essential ones could be the turban for 6. It's also allowed in army. You can see in motor act, they are not allowed to wear helmet because of that. But again, when you go for MRI, the 5 kirpans, right? If you have a kirpan allowed in metro, but if you go for MRI, the kirpan is not allowed. It's the right. It can even essential practices can be regulated. So that's all. Thank you. I hope it's fast today.